Amanda Asbill versus Dr. Geetha Sylvan, 45 CL 11304 CT 48. You hear a motion to continue the trial?
Yes, Your Honor.
All right, you ready?
I am, Your Honor.
All right.
Your Honor, my name is Greg Chrisman, and I represent the defendant in the case, Dr. Geetha Sylvan. I'm sorry. This is a case that involves the claim for the wrongful death of the infant child of the plaintiffs.
Right.
He passed away in the first month of life. And the jury trial, we have a 5-day jury trial that's set to begin September 21 this year. And the reason that we filed the motion is very recently we discovered or figured out, unfortunately, that it falls basically one day after the anniversary date of this child's death. Atlas Asbill passed away on September 20th of 2008, and then the autopsy report comes out 2 days later. And so both of those emotionally charged events basically fall right at the beginning of our jury trial in this case. Your Honor, we sort of put those facts in the motion. I will say, too, that I was not, and I'm not trying to cast blame on anybody, believe me, because when I took over the case or started basically going to the depositions and those sort of things, I hadn't figured it out yet either. My client, I'm embarrassed to say, is the one who pointed it out to me, and then we immediately filed, or very quickly filed the motion. But Nick Burnett attended the pretrial conference when he was still with our firm, and Mr. Burnett left our firm at the end of last year, which is when I took over the day-to-day handling of the file. The basis of our motion, Your Honor, is basically the unfair prejudice that would result to my client of having to try the wrongful death case of an infant on the 7-year anniversary date of the death of the child. I think it goes without saying that there are few cases that come before this court or any other court that are more emotionally charged than a wrongful death of an infant case. Every juror, every lawyer, every judge, everybody who is a parent is going to feel natural sympathy for the grieving parents. My concern and my client's concern that she raised with me is, you know, that sympathy is going to be multiplied 100-fold, and how do we get around the risk that this jury is going to decide their verdict not based upon whether Dr. Sylvan met the standard of care or caused the actual death of this child, but based upon the unavoidable and very natural sympathy they're going to feel for these grieving parents who are going to be in front of them, unfortunately, at least as things currently stand, on the anniversary date of the death of their child. And so we've asked as a remedy to try to avoid that prejudice, reduce the risk of that prejudice, that the trial date be moved to a different date. And Your Honor, I want to make this clear. We're not looking to gain any advantage. We're simply looking to get what every citizen of Indiana is entitled to, which is under the Indiana Constitution, which is just a fair trial, and to have the jury decide the case on the facts and the evidence rather than sympathy.
Okay, Mr. Westland.
Thank you, Your Honor. We did file, the motion to continue the trial was filed on June 22nd of this year. I guess I have to back up a little bit. Last August, so approximately a year ago, we sat across the hall in B212 setting this trial date, and Mr. Chrisman is 100% correct. It was Nick Burnett who was there for the defense. Judge Van went through 5, 6, 7 trial dates to get this thing set. And all of them, there was an issue, and I will tell you, Mr. Burnett sat there with the calendars of all his expert witnesses as Judge Van gave us alternatives for trial dates, trying to coordinate the trial date with his expert witnesses. And it was finally arrived at this date, which was 13 months after the last status conference. We finally got a date that fit both Mr. Burnett's calendar as well as all his expert witnesses. That's last August. We've been proceeding along since last August with a trial date of September, which is 2 months away. And now, on the eve of that, or the relative eve of that, we get a motion to continue because now, as Mr. Grisman has pointed out, they figure out that it's in close proximity to the anniversary of the death. It was in close proximity last August. It's not on the anniversary of the death. We've asked, we're ready, we wanted a trial date this spring. And because of the expert witnesses that got pushed all the way to the fall, those were the first dates Judge Van was giving. As far as the fair trial, Your Honor, number one, it doesn't occur on the anniversary of the death. It's the day after. That's number one. Number two, with a limiting instruction, as I'm sure they're going to propose, as they would in any case that involves the death of an infant, the jury will be instructed to decide the case based on the facts and the law in front of them and whether or not Dr. Trabant has met the standard of care. These people are entitled to their day in court for a year now. They thought that day is coming. And to now continue it again to a date further out, Your Honor, we would object to it. And we're asking that the court date be, that the trial date be set at the September 21st. It's the date we've been working towards since it was set in last August in terms of the expert witnesses. And I can tell you, I think Mr. Prisman will agree with this, that since Mr. Burnett has matriculated on to Indianapolis and he's taken over, we have worked well in accommodating the depositions of the experts. Those are all going to be done in time for the September trial date. It's the date we've been working for, and it's the date my client expects. And I don't see any unfairness to the defendant as long as the jury is instructed properly. So to do it on the eve, to continue it now on the eve because now the defense has figured out, or now they've looked at it. I mean, that's something they should have looked at back last August when Mr. Burnett was not agreeing to the other 5 or 6 trial dates that Judge Van was. And we should have gone then, we should have been to trial ready. We should have been to trial in June, we should have been to trial in May when all the other alternatives were on the table. And the reason for we couldn't do those is because the defense experts couldn't be present. So I sat there agreeing, fine, give him another date, Judge. Fine, give him another date, Judge. We gave him another date, and now we're here 2 months before, and they want another date.
Okay. Anything else, Mr. Christman?
Just brief response, Your Honor. We talk about another date and another date. In this case, nobody has ever asked for a continuance of the trial. This is the first time we've asked for a continuance. I don't believe that a limiting instruction or an instruction of any form can obliterate or erase the knowledge in the jury's mind that in front of them sits these grieving parents who are here basically on the anniversary date of the death of their child. I don't think you can eradicate that sympathy, and I think that the case should be decided at a time in which they can decide it fairly on the facts and the evidence.
Well, how's the date, any date, eradicate the sympathy? I mean, it is what it is.
I don't disagree with that, Your Honor. It won't eradicate sympathy, but it will not multiply the sympathy as it will if you. I know that they're not going to try murder cases on the anniversary date of murder. The wrongful death claim for an infant is as emotionally charged as would be a murder case.
The problem, Judge, is if you move it to the spring, then you're at 7.5 years, right? If you move it to around Christmas, well, now it's the holidays and the grieving parents are there. I mean, this
case sounds like this case is never going to have a good date to try. Well, I'm going to deny the motion. We'll reaffirm the trial date September 21st. I really don't see. I mean, the sympathy in this case is going to be there regardless. I mean, I won't let you pound on it, that this is the anniversary date and this, that. You know, you raise a proper objection, we'll hear it at the time. If council tries to use that date to his advantage. Okay? Anything else?
Just one thing, Your Honor. We did have also a motion that to continue, not continue, but change the date of the pretrial conference because I'm stuck in a jury trial in Marion County. It's unrelated to this motion, but...
I don't have a problem with that, do you?
No.
What day was it set for?
August 19th, I believe.
That sounds right, because I'm in a 2-week jury trial.
Alex, getting it out of here.
This morning, I thought it was August.
It's usually 30 days before the trial we set them.
It is the 19th at 11 a.m., Judge.
You want it after that date?
If you do it on Wednesdays, the 26th certainly works for us.
You have it?
I mean, it's up to you. I'm not...
I think we have it. We'll see. Okay.
I'm supposed to be in a jury trial on the 26th in front of Judge Monk.
All right.
The 2nd of September is open, as well as the 9th.
What time of day do you do this?
We'll have you open. I may have the whole...
I can do like late morning on the 2nd.
Okay. 10:30?
That'd be great.
Okay. Anything else?
No, Your Honor.
All right, thank you, gentlemen.